Tuesday morning, FH&P Law Talk. Nancy Ling joins us, and now that we've set aside Paul Johnson and his tree surgeon, tree farmer, lumberjack misadventures, don't try that at home, folks. If you got to cut a tree down in your backyard, unless you're really good at it and you've been around trees that have been falling before, hire somebody to get one of these tree guys to come on, Asplund or whoever. There was all kinds of them out there. Paul, if you're listening, I hope you feel better soon. And sad to hear what's happened to you, but you just become a living point of reference. Do not do this at home. Do not do as I do. Hire the professionals to do it, which is why we talk to lawyers. Hire a professional lawyer rather than trying to do it yourself. Where are you taking us, Nance?
I'm going to talk a little bit about survivorship, what happens when families have common disasters and everyone dies at the same time, or if someone goes missing and they're presumed dead. What happens in that case?
And what kind of a will do you need? Okay, so very quickly, maybe you can help me here. I realized I need to update my will. Things have changed a lot in my life over the last years. I moved, and it was reason to look everywhere. And I cannot find it. I cannot find my will anywhere. So I'm going to have to come in and see you and draft and draw up a new one. Have things changed a lot over the last 10 years?
Well, things are always changing, but not so much that you would need to redo a new will. For the most part, we plan your wills to last as long as possible, which is why we ask some of these ridiculously morbid questions about common disasters.
Morbid questions.
Right. So we ask, what do you want to do? And, for the simple mom and pop will, it'll be everything to the spouse. If we're both gone, then everything to the kids. And then, we say, what if all of you are on the same plane? Then, to any grandchildren, then, what if they're on the plane too? What if the whole family is gone? Things like that. So you
actually take the person sitting opposite your desk and say, what would you do if?
Well, we go through the different alternative things that could happen to your family. So you don't have to redo a will every time there's a change. We try to plan ahead of that.
So we write a will with the eventuality of a disaster that wipes out the entire family?
Yes.
Wow.
Well, one of the things...
Hurricane or tornado swoops down and comes across and carves a swath through the city, and your home disappears, and so do you.
Right. So we'll draft the will for all of these, and hopefully we'll put in enough eventualities that you won't have to draft another will. I mean, on the plus side, if you've got a young couple just getting married, we'll draft in potential children, for example, right? And on the other side, for older families, we're drafting in the possibility that your children might predecease you. So we do look at that. But what happens is the way we draft wills is usually if so-and-so survives me. And sometimes we say they're only going to get their inheritance if they survive me for 30 days or 5 days or something like that. The reason is because if two people die in the same accident, we don't want to have to probate two estates and do two estates because a dead person is inherited from another dead person. And so traditionally what used to happen is if we couldn't tell who died first in these scenarios, the presumption used to be that the younger person survived the older. And the problem with
why is that?
They just made a...
It's a precedent setting, and everybody continues.
It comes from England. We followed suit. Essentially, we assume that the younger person survives the elder person.
So the younger person had more resources, was in better health physically, and even though they died 5 days later, but effectively the younger person outlived, even if by hours or days, the older person.
Right. But that caused problems because the Insurance Act here in BC said the opposite. The Insurance Act says that if circumstances are such that you can't tell who died first, then it's presumed that the beneficiary died before the insured. So essentially, they're not going to give life insurance policy to somebody who has died at the same time as the insured. So
why would that be? I'm just intrigued. I'm going to ask some dumb questions here. By the way, we'll take your calls at 250-862-2525 if any questions occur to you. But I'm struck by, why do we decide that if we were both involved in a car accident, why do we decide that the guy at the wheel didn't die before the woman sitting beside him on the right-hand side of the car.
It sort of follows the purpose of life insurance, right? You're leaving the money if you die to a beneficiary. But if that beneficiary dies at the same time as you, they're saying that wasn't the intention then. Then it would go through your estate.
But if I can jump in here. So he's at the wheel, and he has 2 children. She's in the passenger side. It's a remarriage for both of them. She, in fact, actually did outlive him. He died instantly when the airbag on the steering wheel exploded or whatever, and he died. She was alive longer than he. The paramedics arrived, and she survived by 2 hours longer, and then she too expired. Do his kids inherit the will, or would it refer to her because she was the passenger and she lived 2 hours longer? Effectively, he predeceased her. His will indicated that on his death, all would fall to her.
Okay, so...
Sorry. I find this fascinating.
Under the Wills, Estate Succession Act now,
Yeah.
Which came out in 2013, there's a 5-day rule. Regardless of if you can tell that they survived by a day or 2 or 3,
right,
you need to survive by 5 days in order to be entitled to inherit.
Interesting.
As a survivor. And there was a case actually not that long ago where they actually figured out exactly how you count that. So husband and wife were both 92. The husband died on January 12th and the wife died on January 17th. And they looked at what
5 days.
Time of day that they died. Is it clear days? Do you have to have a clear 5 days in the middle and we're looking at the 6th day? Or, are you excluding the first day, including the last sort of thing? And what they said is it's not by hours. It's not, if it's 5 days, but it's 3 p.m. versus 5 p.m. And that would, in fact, be 5 days, January 12th to January 17th.
So it's truly 5 24-hour periods.
Yeah, we don't look at days in fractions. It's
right.
Just a full day. So if you're alive on that 5th day, you've survived. So if the wife did die a matter of hours or even a day after the husband, for the purposes of the will, she would be presumed to have died before him.
And the estate stays with him as opposed to being handed to her.
Well, again, we would have, if he had a will, it would have been drafted to say that if my wife survives me, and then you read in for 5 days, if there's no other provision there, you can lengthen it. You can say 30 days, but you can't shorten it.
What's the reaction of people that are sitting opposite you when you ask these kinds of questions? Are people shocked? Are people... does it really set them back? Because it strikes me that there are some questions you'd ask here that people would be saying, whoa.
No,
hang on here.
Most people, when they come in for a wills interview, they're ready for this exercise, right? They're ready to talk about what should happen if they die and look down the line a little bit. And if I do suggest that they want to consider what happens if their children don't survive them, and they're like, well, that's a long way down the line, we don't have to worry about that, then occasionally I might throw out these morbid worst-case scenarios, play the devil's advocate. As a lawyer, sometimes it's our job.
To give them an example of a scenario and what can happen.
You're all on the same flight to Disneyland.
There you go, and we all go at the same time. I need to take a break. When we come back, we're going to continue this conversation. Absolutely fascinating. Nancy Ling is here from FH&P Lawyers. It's Tuesday morning, our Tuesday morning law talk. Back in a moment. Fascinating conversation this morning as we talk with Nancy Ling from FH&P. We're talking about who left first, who leaves first, and where does an estate fall to. We'll continue the conversation, but first of all, we go to the phones. Lynn wanted to join the conversation. Lynn, good morning to you.
Good morning.
Thanks for joining us.
Thank you. We were discussing with friends of ours yesterday, just over the coffee, we were discussing wills. And these friends of ours said that they have to get their wills redone because they have made the executors are also the beneficiaries. Is that correct?
No, you can have your beneficiaries as your executor. That's not a problem.
Or more to the point, your executor being the beneficiary.
Right. A lot of people...
Which comes first?
A lot of people will have their husband as their executor and will also leave their estate to their husband.
That's like ours has gone to... Mine has gone to my husband. Then if he predeceases or is unwilling or whatever, then it then becomes my daughter and son as co-executors.
Yeah.
So that is allowed.
That is allowed.
Perfect. Thank you very much.
Well, how easy was that? Thank you very much, Lynn. I appreciate your call. Kind of gives us a little bit of clarity.
So one thing that brings up that I want to point out is this 5-day survivorship rule doesn't apply to executors. We don't have any holding pattern on the executor's authority. They don't have to wait the 5 days until they're allowed to act.
Okay. All right. So let's go back to our couple, both involved in a traffic accident, who predeceased who, and so on and so forth. You said you had some examples of these kinds of scenario stories that are out there.
Right. So I'm going to start with one that happened under the old rule, and I'll talk about how it went. And then
what would have happened
exactly
under the new rules. Okay.
So this is an older case, again, before WESA came in, Leach and Egar. And it was a story about a couple who divorced, and within a year after the divorce, the mother took her 2 children, 17 and 19 years old, on a sailing trip in the Caribbean. They were lost at sea, so it was unclear who died first. Under the old rule, the youngest would have survived. So it's presumed that the mother's estate trickles to her son, and because he died without a will and had no spouse or children, his estate goes up to his surviving parent. So in that case, the divorced father inherited his ex-wife's estate. So it was the woman's mother that brought the case against her son-in-law to say that shouldn't happen.
The wife would never, ever have agreed to this because they were divorced, and the idea that her estate would fall to her ex would have her turning over in her grave.
Essentially, yes. But under the new rule, that wouldn't have happened. Under the new rule, we don't want to have estates trickling through other deceased. So what we assume is that none of them would have survived the others for the purposes of each individual's estate.
When the boat went down, we all died at the same time.
Essentially. Well, if you look at the mom's estate, her estate would be viewed as though her 2 sons had died before her.
Right.
When you look at the 19-year-old's estate, his estate would be viewed as though his mother and brother had predeceased him. And the same thing with the 17-year-old. So each one of those estates is administered as though the others had died before them.
And then where would that estate go? Not to the ex-husband.
Right. So all of them died without a will. So the mother's estate, if her children predeceased her, would have gone to her mother.
Right.
Because assuming she didn't have a new spouse at that point.
Right.
The kids' estate, so assuming that their mother predeceased them, the kids' estate would still go to their father, but they wouldn't have the money from their mother's estate.
They wouldn't have received their share of the will from the mom.
Mm-hmm.
Okay. This gets incredibly intricate.
It does. And so we've got 2 more little hiccups to throw in there. One is if couples own property in joint tenancy, like houses, for instance.
Right.
Unless you draft a contrary intention in your will, you can't tell who survived the other, so you can't do the right of survivorship that you normally would with joint tenancy. So that joint tenancy is severed, and each person's half goes through their separate estates.
So you liquidate the property, and then depending on what your will may have specified, your half of your estate goes to. Listen, let's go back to the phones. Ron, good morning.
Good morning, Phil. Good morning to your guest.
Thanks for joining us.
Thank you. I just have a quick question. Hopefully this will relate to what you're talking about. I'm thinking in my will, changing my will from giving everything to my kids to putting an addendum in that says that my grandkids, and I got 4 of them, will get 5% of my property when I die. Does that affect anything as beneficiaries? Is that done?
Yeah, you can do whatever kind of gifts you want in your will and whatever combination of gifts. So if you want to give a specific percentage to your grandchildren at the same time as your children are receiving the rest, you set that out. If they're all surviving, then your grandchildren would get the 5%, and whoever else your beneficiaries are would get the other 95%.
Yeah, and I would make it, I'm thinking of making it so that they don't get it until they're 19 or 21 years old. That doesn't affect being a beneficiary, though. If there's an accident, some terrible thing, and we were all gone, and only the kids were left, they would still be beneficiaries of the whole thing, I guess, rather than the smaller amount?
You still draft for any eventuality. You would say, I want my grandchildren to have 5 and my children have 95. But then you say, if my children should predecease me, what happens to their 95%? Is that also going to the grandchildren?
Oh.
Or if the grandchildren die first, what happens to that 5%? You still draft for all eventualities.
So, it sounds to me I have to go to a lawyer I was going to think when I go to the Notary Public, this is more like something I think that a lawyer has to handle, right?
It helps.
From what you just said, I think it really does.
Ron, I'm intrigued, and it was funny because we had an off-air conversation between myself and Nancy, and I was saying that my estate, I have no spouse or anything, so my estate will fall to my son. But when my mom passes, and Lord knows when that will be, she'll probably outlive me. But when she passes, there will be a reasonable inheritance. But I've stipified, or I want to, in the new will that I'm going to have to write with Nancy, I want to stipify that inheritance will not fall to him until he turns 35. And I figure the next 10 years will be big years. He'll make his mistakes. He'll screw up all the things that he screws up. And then when the inheritance arrives when he's 35 years of age, he'll be far more equipped to deal with it.
And I was thinking, the age I was thinking about, too. The biggest thing is that I can give it to my kids, but they can pass it on to my grandkids. But if property's where the money is,
yeah.
And if it keeps escalating like my mom's did in Vancouver up to $1 million, it would be nice if they had a chunk of that without having to get it from the parents.
Yeah.
Mm-hmm.
So, yeah, I think I will. I have to give you guys a call because I'm dealing with you on something else and maybe have this change because I can see where it could be.
Ron, good question. I really appreciate your time and the call. Thank you so much. Till we can continue down this road. Okay. Dan's giving me the high sign that we need to take a break. So we'll take a break. We're on our Tuesday morning FH&P Law Talk, which is a fascinating trip that we're taking with Nancy Ling this morning as we look at survivorship and what happens when everybody dies at the same time. The most tragic of those instances was with mom, dad, and all three kids on the same plane, and it went down. What happens then? Believe it or not, Nancy Ling knows how to write that into your will. Back in a moment. Well, it is a piece of law that I'm sure that many of you have not given much consideration to when you board that airplane and you and your husband and your two kids are heading for the happiest place on earth, Disneyland. And yeah, there's everybody's heart beats a little faster on takeoff, and you think, what would we do if? And if doesn't happen very often, but if it does, and if becomes the reality of your life and your family, was your will, or did you have a will, or were you prepared? And that's certainly the subject that Nancy Ling has taken us today. Any other case histories? I am absolutely finding this morning fascinating, and I thank you for bringing the subject forward.
Well, the last thing that I wanted to touch base on is in these scenarios of lost at sea or lost in the bush or things like that, sometimes we don't actually know if a person has died. In that instance, you've got these missing persons or presumed dead. So at common law, if someone's gone missing, they're presumed dead after they've been missing for 7 years. But sometimes you need things to move along, or you need to deal with property before 7 years is up. So what you can do is make an application to the court to have someone presumed dead if you have enough evidence to convince the court that that's the most likely scenario. So in BC, we've had a couple of cases like that. Two of them that I found looking around last night had to do with husbands or boyfriends that had gone missing, and you like to submit proof from the police who are doing the missing persons case or whatever, or whether it's been transferred to a homicide case. And both of these cases that I found dealt with people who had some affiliation with the Hells Angels. So it was the evidence of whether or not they'd met some misadventure, and it was more likely than not that they'd actually been buried somewhere. And in one case,
you're never going to find the evidence.
Essentially, in these cases.
And the evidence would have been a corpse if one had existed.
Right. And in both these cases, the evidence of the police was determinative, because in the one instance, they had information from a confidential informant saying that, yes, this person was in fact deceased.
Was removed from the picture, so to speak.
Right. And in the other case, the evidence showed that this man had been hiding away funds offshore for years and had been living very lavishly and had the means to run away and hide. And it was equally as likely that he had gotten into trouble with the Hells Angels and had run away to hide as it was that they had actually killed him.
And actually decided that he wanted to disappear, and now was the time to disappear.
Yeah. So in those circumstances, they did not presume him dead. They said, you've got to wait your 7 years.
Oh, really?
Mm-hmm. In the first one, where the confidential informant had information, they did presume him dead.
Right.
Mm-hmm.
But even though somebody wants to disappear and effectively move themselves from the landscape, if there's no reason to think that you have met an untimely end, never mind whatever connections you may have, we're going to presume that you're alive, and your will be held in abeyance for the 7 years, and then you can apply to process.
Right. And if you do need to protect the property in the meantime, you can apply to have a curator of that estate, someone to look after this estate of this missing person.
I think that side of the story is fascinating. I doubt that very many of us I doubt that very many of us have gangland connections somewhere in our historical records such that any of that would come to play. But the other side of it is definitely very real, which is that, yes, people do disappear, and that there may be some evidence that would indicate that they might have been murdered. I know someone very close to me whose mother was killed, murdered, shot. You meet an individual, and then you hear their life story, and then you hear, my mom was shot, etc. And my jaw dropped when I heard the story, and just all the emotional ramifications that rolled through life and the lives of other people who are left behind, the emotional impact, the strains on relationships, and so on. That brutal death is powerful beyond belief.
Yeah, well, there's no telling what can happen, so we do our best to try and plan.
And that's your job.
Yes. Is
to think of all, and let's, to be fair, you've brought a couple of case histories forward that then, I guess, in the mind of the person sitting opposite you at that desk, suddenly begins to help me understand and help me realize that while we think the worst is not going to happen, while it's beyond the ability of most of us to imagine a scenario whereby, but it does happen.
Mm-hmm.
It's that being in the wrong place at the wrong time on the wrong day in the wrong hour.
Right.
And your life is then changed forever. Fascinating. This is a home run one. Maybe it's just me. Maybe it's just because it appeals to my inquisitive nature, I guess, for lack of a better way of putting it. But I thank you for bringing the stories forward.
My pleasure.
I've got to tell you that if you'd like to write your will, if you'd like to, investigate further, she's always willing to talk and always willing to take your calls. Nancy Ling can be found at FH&P, deals with wills and estates and writing wills and how to put them all together. People can find you at
250-448-0527.
And I can attest to the fact that is her direct line, and she does answer her own phone. Nancy, thanks for being here.
Thanks for having me.
Always appreciate.